Okay, I'm Dan Haggerty, and this is the part of the newscast where I invite you to join the conversation. What do you think about the local news? What are we talking about? Are we glossing over important topics? Please let me know. Email me at dan@WRAL.com. It's right at the bottom of your screen. Now, tonight, let's start a discussion into affirmative action, or race-based admission decisions from our colleges and universities, because it could go away after a lawsuit filed against the University of North Carolina. Here's the latest headline. Supreme Court to consider landmark challenge to Harvard and UNC affirmative action policies. Now, the plaintiffs here are arguing that those schools are using quotas to cap the number of Asian American students that they accept in order to reserve spots for other minority groups like black students. Now, the key word to take away there is quotas, which are a no-no. This can all be a little bit confusing, so let me try to explain from the beginning. The term affirmative action was first used in the 1960s by JFK to discuss problems with discrimination in the workforce. The idea was kind of vague at the time, but the goal was simple. Basically called on institutions to hire more black people after decades of direct action to block blacks from certain jobs, access to housing, education, things like that. Then, paired with the civil rights movement, that idea started to take shape. And by the 1970s, major colleges and universities across the country had adopted some form of affirmative action, mostly by setting aside spots that were exclusively reserved for minority applicants. And that's when Alan Bakke came along. You see, in the mid-1970s, Bakke, a white man, got rejected by the University of California twice, despite having higher test scores than some of the black students who were accepted, who filled spots reserved exclusively for minorities. Now, Bakke sued over this, and the Supreme Court agreed with him. Look at the headline from the LA Times at the time. Bakke wins, but justices uphold affirmative action. See, they decided two things in this case. One, the racial quotas were unconstitutional. You can't have special spots for a specific race. And two, that diversity is important for a thriving society, and race can't be ignored when striving for diversity. Justice Harry Blackmun wrote this at the time: in order to get beyond racism, we must first take account of race. There is no other way. So, schools stopped designating special spots for non-whites and started using race simply as a factor. Now look, schools consider lots of factors when you apply other than your test scores. Maybe you're the class president or first chair in the school orchestra. Maybe you write for the school paper, play on the softball team, or you volunteer at a local animal shelter on the weekends. All that stuff helps. And with affirmative action, your race is also considered a factor in the name of diversity, which unfortunately in this case is a word that's very difficult to define universally. I mean, how do you know if your school is diverse or diverse enough? And if you decide it is diverse enough and use the race of new applicants to continue that level of diversity, wouldn't that be a form of a quota? It's a gray area that's led to a lot of disagreements and many challenges to affirmative action over the past 40 years, including the most recent one we're seeing involve UNC. Now, so far, the Supreme Court has ruled in every case that race still deserves to be a part of the process. I know this is a touchy topic for a lot of people. It's easy to get emotionally charged. I watched some local news coverage about this recently, and I heard an anchor ask a reporter, so do the plaintiffs think affirmative action is actually bad? And that kind of rubbed me the wrong way, because affirmative action isn't intrinsically good or bad. It's a tool. I mean, we know that race matters in society. How and to what degree is constantly changing and being debated, just like the tools we use to deal with racism in this country. Let me put it this way. In 2003, the Supreme Court, they upheld affirmative action in a case, Grutter versus Bollinger. Here's some C-SPAN video from the time. It was a case involving a white woman who didn't get accepted into Michigan Law School. Now, in a majority decision, Justice Sandra Day O'Connor held that while the use of race was acceptable in this case, she said, quote, race-conscious admissions policies must be limited in time, and that the, quote, court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interests approved today. Now, before you say, of course she said that, Dan, she was a Republican. Well, progressive Justice Ruth Bader Ginsburg also sat on that court and concurred with the judgment, though she did disagree with that specific 25-year timeline. But Justice Ginsburg wrote that race-conscious programs, quote, must have a logical endpoint. Now, some people believe with the conservative makeup of the current court, that endpoint may be sometime next year. So I guess we have between now and then to discuss if it's logical. Again, this is a discussion. I know there's a lot more to discuss. They only give me a few minutes up here. So if there's something you think I haven't said, something I missed, something you think I should consider, please email me at dan@WRAL.com. And feel free to ask complicated questions. I know how to get in touch with the experts and the right people to help you get answers. Dan@WRAL.com.